So, good morning, and thank you for staying on for the second panel of the symposium. My name is Shauna Wilson. I serve as the Justice Team Leader in the State Department's Bureau of International Narcotics and Law Enforcement Affairs. I have to give you a disclaimer that I am here kind of in my personal capacity. So anything that I say today is attributable to me and not the Department of State or INL. And with that disclaimer out of the way, let's turn our attention to the point of today's panel discussion. And I'm really looking forward to hopefully a very fruitful and engaging discussion. And I hope you all have a lot of questions and insights to share with all of us as well. Over the last, I'd say 15 to 20 years, a number of countries and regions throughout the world have made major changes in the way that they handled their trials. You're seeing a major switch from an inquisitorial system where the trials are pretty pro forma to moving to a more adversarial system where your trial is your main event. And one of the questions I hope that our panelists will talk about today is not the technical aspect of that transition, but more of the mental aspect of it. So we spend a lot of time on the how. How do you do direct and cross-examination? How do you conduct a plea bargain? But do we spend enough time talking to people about why we do those things? What makes that important? What is fundamentally important to you as a judge, as a neutral arbiter? Why the equity of arms of party is so essential in any sort of adversarial system. And I know in a number of countries that I have been fortunate enough to work on, and through INL, we fund a lot of training on criminal procedure reform. And in talking kind of offline with judges and prosecutors and defense attorneys, there's a disconnect. They're thinking for judges, woohoo, I don't have as much work. I no longer have to be engaged. I can just sit back, relax. And I'm thinking, oh, no, you don't. And so it was very interesting to me, this conversation of the why. And so I'm really looking forward to our panelists talking about that today. I'm not going to spend time going over the very distinguished bios because you all have that, but we do have an excellent panel representing and giving a variety of different insights and experiences that they've had. The way that we're going to do today's panel is we're going to start with the experiences in Latin America. Latin America has been dealing with kind of these procedural changes probably the longest, say over the last 20 to 25 years. Then we'll move and look at Rwanda, that's kind of been dealing it with about 3 or 4 years. And then we'll wrap up with Ukraine, where it's not completely implemented. And so that we can kind of see the trajectory and see how things have flown and have we learned anything in this long period of time. And with that, I'd like to turn it over to Judge Musetti, who has worked on Latin America countries and doing criminal procedure reform for a very long time. And so he has a lot of insights to share with us.
Thank you, Shauna. The first thing I want to do is make sure that everyone here can hear me. I did have a little bit of difficulty hearing some of the speakers in the last session. Can you hear me on the side there? Very good. I'll continue to speak in a loud voice then. Well, let me jump right into the topic, and I'll probably have a few detours along the way. I'm talking about Latin America now, so we're talking about Spanish America and Portuguese America, which is to say Brazil, although you have to remember in the Caribbean there are some English colonies that have always followed the system of Great Britain, and there are some one or two French outliers as well. So they really are not so much part of the conversation this morning because they have their own distinctive traditions, but we're talking really about Spanish America and Portuguese America as we speak. And the heritage really of those systems in Latin America is obvious. The Spanish colonies, even before they became independent in the early part of the 19th century, followed the Spanish law, the Siete Partidas, which had a whole chapter on criminal law and criminal procedure. Basically, inquisitional, follows what was done by the Catholic Church in regard to religious matters, what was done by absolutist monarchists who were in alliance with the church. And you all know what the drill was there. It was basically closed proceedings by an inquisitor. If you read the Brothers Karamazov, you know about the Grand Inquisitor. The inquisitor who did the investigating, who did the interrogating, who did the deciding, who did the punishing. And frankly, you still saw characteristics of that system as late as the 1990s in many countries. That's what it was. They were secret proceedings. They weren't open to the public. They were largely written. In many cases, the deciding person didn't even have direct contact with the witnesses. Because it was in writing, the statements were taken by some sort of clerical assistant and they were read by the judge later on. That was characteristic of a lot of countries in Latin America. The Portuguese Portuguese system came to Brazil in much the same way. There were what were called ordenações that were in effect in Portugal, basically again deriving from the canon law and some of the, even going back to the Roman law, the idea basically being inquisitional. And that was what was brought to Brazil. And essentially these factors continued through the 19th century, through even part of the 20th century. You still see remnants of the inquisitorial system in countries which proclaimed to be adversarial in large part. Brazil's a good example. They leave their investigation of the cases primarily to the police, what they call the inquéritos policiais. The police do the investigations and they turn it over largely to the prosecutors to then decide how to charge and so on. So you still see those remnants that are out there. It really was in the 1990s that the movement toward adversarial systems picked up steam. I want to tell you a little bit about a personal experience, though, just to show you how things move along. In the 1960s, I was a Peace Corps volunteer in Brazil and was recruited in part by AID. Some of you are from AID here, I believe. Well, great respect that I have for AID, I need to tell you that there was an arrogance that was quite evident in those days. The feeling was that if we could teach Brazilian lawyers to think like American lawyers, then everything good would follow, including economic development. So I was part of that project, sort of informally, to come in and try and talk about the Socratic method in the law schools. We tried, and they still do largely the lecture method in the Brazilian law schools today, although there are some remnants. The Getúlio Vargas Foundation in Rio and Sao Paulo are people who graduated from that earlier system. So this is a sort of a leitmotif that's going to follow through the conversation, that always there's something that's taking hold. It's not always everything all the time. It's something somewhere along the way, and who knows whether it germinates later on. That's really that's going to be my last word to you as well, that these processes take a lot of time to happen, and we're 25 years or less into various countries in Latin America, and we'll see. All these countries were under dictatorships for the large part, most of them, military or otherwise. With the fall of these regimes, there was an issue of transitioning to democracy. Human rights became very prominent, and so the issue of criminal law justice, which is really right at the core of human rights, became a very prominent issue. And the United States had a great deal to say about those things. But again, we need to focus specifically on the kinds of problems that came with the inquisitorial system in Latin America, and I think they're characteristic of many countries where the largely inquisitorial system is in place. I mean, you have arbitrary arrests that are not monitored, really rarely access to bail, which is to say pretrial release. People languish in jail for periods of time, sometimes longer than their sentence would be if they were actually tried and convicted. Limited disclosure of evidence, secret proceedings in the sense that they're closed to the public. The judge has been typically the investigator and the decider and the sentencer, and the sentences could be unduly long. And then there are all these sort of byproducts of this, like bad prison conditions that result. I mean, there's so much that flows from so many of these things. And of course, corruption, absence of transparency, a continuing issue. That's the way you alleviate some of these issues. You make your case go faster, or you get a better result if you can pay the decision makers or people who are in the chain of command. And I might say as well, there are racial and economic disparities. And some of these things, of course, apply in the United States too. I'm not defending everything that happens here, but certainly I would say economic disparities, the feeling that people of the elite, of the upper class, the politicians, really don't get their punishment properly, but the folks at the other end of the scale surely do, and then some. Those are all characteristics of what you've seen historically in many countries in Latin America. Now, I talk about the 1990s as being kind of the watershed, but in fact, a number of countries, Brazil, Argentina, and others, began to try and do things before that were more in the way of due process of law. Interestingly, the actual concept of due process in Brazil didn't get put in the Constitution until 1988, although there were ideas of due process that were out there. Still, it took a while for some of these things to come to pass. The fair statement is that today in most of the large countries of South America and many of the Central American countries and in Brazil, that they have moved in various degrees to an adversarial system, which is to say that investigation is taken out of the hands of the judge. It's put into the hands of either the police or the prosecutors, who work more or less in tandem to investigate cases, that there is a prosecution that's taken care of by the prosecutor, and that the judge is more of a referee, of an arbiter, than historically has been true in the inquisitorial system. There is, in different degrees, there is orality, which is to say that there are oral statements made by lawyers at the beginning of some proceedings in some countries, that there is some direct examination and cross-examination by lawyers, although one still sees the judge doing much of the questioning in these countries. There aren't jury systems except in some unusual situations. The province of Cordoba in Argentina has jury trials. Brazil has jury trials when homicide or attempted homicide cases are involved. An interesting dynamic. I don't recommend that for anybody anywhere, but juries do have a certain kind of a chastening effect, and we can talk about that perhaps another time. But you do see, as I say, in various degrees in a number of countries, probably the majority of countries of Latin America, it's fair to say, excluding the Caribbean, that there is some movement toward the adversarial system. And you have oral trials. That is, there's a lot more orality, although in many countries still, the judge, who is the decider, since there aren't juries, is required to do a written decision. Less true in the American system, for example, where a judge can simply announce a decision, or so can a jury in a criminal case. One sees as well concepts such as vigorous public defender systems, the opportunity for bail, release on personal recognizance, that 5 minutes, wow. All plea bargaining, of course, has come into play in a lot of places, and that makes the system move a lot faster. Still, we're working on various efforts in various parts of the country. Let me review quickly some countries where there's been some activity. ABA Rule Law in Latin America Committee, Mike McCullough is here representing them today, has done work in Ecuador, and they have provided support for accusatorial training, which has to do with all the techniques of a trial that we've heard spoken about. Mexico as well, not the whole country, but in a number of prominent states, has also implemented adversarial techniques, largely promoting the bar associations and the law schools in these techniques. But Baja California, Chihuahua, Estado de Mexico, the Distrito Federal are all provinces that have had some training in this regard. ABA Rotary has been in Panama, in Peru, And then there's some other people, not ABA Rotary, who've been involved in other countries. Chile is a shining example of how they've made a successful, I think, move toward the adversarial system. They've reorganized their courts, and they have various other kinds of improvements, more rights for the defendant generally. Colombia is another country which, despite overall violence, has done something with regard to improving adversarial conditions. Guatemala, I was just there earlier this year, has a one-stop shop. When you go in where the lower class folks are grabbed, they walk in and there's a judge there, and there's a defender there, and there's a prosecutor there, and everything gets done right there, all at once. That's a AID project that I applaud. I think Czechia is involved in Colombia, if I'm not mistaken. Anyhow, a number of issues are out there. Things are not perfect. There are still issues of ingrained practice. Judges are not that attuned to dealing with oral concepts, nor are lawyers, some dilatory practices, and so on. Violence continues in a general way in Central American countries and otherwise. But let me just read to you in closing. Do I have time to close?
Yes, you do.
Two statements. One was sent to me by Mike McCulley yesterday or the day before, I can't remember, from the Attorney General of Mexico, and this is what he says. This is what the article says, September 24th, 2014. With less than 2 years until the new criminal justice system, Nuevo Sistema de Justicia Penal, is slated to be fully implemented and operational nationwide, Mexico's Attorney General recently spoke of the challenges inherent within the new system. Addressing the Chamber of Deputies, Jesus Murillo Caram explained that the switch from an inquisitorial system to more of an accusatorial system based on oral trials is not just a change in the justice system, but also a change in mindset. Quote, it is about fundamentally constructing something much more difficult, a new mentality, a new form of justice that requires a new perception of public servants, those that work inside the vocation, that have the ethical principles that a public servant requires to impart justice, and that can apply the law and support it. And finally, this word from an Ecuadorian public defender. He says this. He has no doubt that Ecuador will someday have a successful and fully realized adversarial system. He says, what we are doing here is like building a cathedral. We are building it for our grandchildren. Rosy words, maybe overstatement, but basically positive. And I say that is overall my comment about the Latin American situation. Basically positive, moving toward a positive future, long road ahead.
Thank you. Thank you, Judge. And so now we're going to move from a more kind of extensive history to kind of a relatively new in Rwanda in the last 3 or 4 years with Professor Kamatali.
Yeah, let me just get this a little bit closer. Thank you. I hope I can just, is it loud enough, right? So let me see if I can get this here. You know, Rwanda experience with the system has been part of like a choice, but also a duty, because as you probably remember, it was in 1996 when trial genocide started. And we have a situation where 140,000 people in jail. So if you use the best, criminal system, it's not going to be working. So one of the approaches that actually was innovative was to incorporate some aspects of accusatorial system, and also looking at issues like confession and guilty plea, which was more about helping to reduce the overpopulated prisons, because if people could plead guilty and then the trial would be fast, so that was a way of speeding trials, which was kind of a need the organic law introduced. And Rwanda was historically a civil law system colonized by Belgium and also speaking French. So in 1994, we kind of found ourselves in a situation where we have to kind of look for the best solutions. So the best solution that was introduced that time in 96 was this aspect, confession and guilty plea, out of the need to speed up trials, which actually Rwandans realized that there is something positive coming from the accusatorial system, which is more basically this guilty plea. And then in 1998, when I got back to Rwanda, I was kind of the dean of the law school, and that was the time when we kind of try to kind of combine both the civil law system and common law system, and that was also related to the need to incorporate the both French speaking and English speaking. And the problem in Rwanda was that how do you teach civil law system in English? Because terminology is very difficult. And you ask somebody as a dean, you teach jurisprudence. You would teach jurisprudence, which is completely different in kind of like a teaching precedents and everything. So you look at it and say, what is that? And then the issue we had, for instance, related to the Attorney General, the debate that happened between the Minister of Justice and General Prosecutor, who is the Attorney General? And the Minister of Justice saying, no, I'm the Attorney General. And the General Prosecutor saying, no, you are not, because historically in civil law system, the Attorney General is the Avocat General, which is actually different from the civil law system. So you have this situation where you don't know who is who because we're trying to define who is who, and not really, as you said, what is in there, but more the title. Who is going to be the Attorney General, the title, the prestigious title. But what is in the name was not really discussed to know what the Attorney General does. So it was more like, as Attorney General, I'll be the General Prosecutor or be the Minister of Justice. So that was the debate, because the Attorney General under the civil law system, the Avocat General, would be like the General Prosecutor at the level of the Court of Appeal. And that was like, yeah, you'll be lower than the Minister of Justice. The Minister of Justice will say, I have to be the Attorney General, because then I'll be the one representing the government and everything. So that was a big debate going on in Rwanda. So just to give you an idea of how this issue of English, French, civil law, common law was a big fight in Rwanda, but also the fact that we had Rwandans who returned after 1994 who were only English speaking, and also finding a civil law system. So the USID offered to create a project to train English-speaking lawyers. So the English-speaking lawyers was what? We will hire people from East Africa, English-speaking, and they will come and teach civil law system. And we have also the French-speaking who were taught by Canadians, French speakers, but who were teaching at the same time a civil law system. So we end up having kind of like two systems developing in parallel, which was a big problem in Rwanda. So it's only around 99 that we kind of found a way to merge them, but we're still fighting and looking at this, acquisitorial and exquisitorial system, just to look at the list of what actually the differences are, in organization of the courts, the binding force of the case law, investigation, examining phase, all these are the aspects that mostly, if you look at the difference between the two systems, will be different. So using the Rwandan system, where we move from the acquisitorial system toward acquisitorial system, but also in which we didn't know what was useful, because we have a USID in the UK trying to promote the common law system, and then we have the Belgians and Dutch who are also there trying to say, you know what, these things are not really the best. Let's use our own stuff. So, and that is a debate you face when you're dealing with a society like Rwanda, where you don't know, because you're poor and you're waiting for somebody to help you, and then USAID would say we wanted this approach, and then the Dutch and the Belgians would say actually the USAID thing is it's not. So and then being the law school is the kind of a lab where we end up fighting with all these kind of issues. So and just end up finding that our criminal law procedure, which was adopted after all the debates, try to combine both to make sure that Belgians and Dutch have their share, but also the common law approach, because at the end we have to agree that Rwanda, as we conclude later on, is moving toward the common law system because of East African community. We're joining East African community, and we don't have any choice whether we want or not. We're going to be part of the East African community, which is more using the common law system. But the progress is very slow, because who is paying the bill is also defining how fast you can go to, get all these done. So, like for instance, in Rwanda, when you look at the criminal procedure, the code of criminal procedure, we kind of adopted more like the general jurisdiction, like the common law system, but we also introduced the specialized courts, which are more the commercial courts, for instance, which were introduced because the World Bank comes and say, I want to move these, and then you have to get these commercial courts, which is a good thing and helping and speeding trials. But also military courts, because of political reasons and others, you have to keep military courts so that you can keep, people outside. And then in Rwanda also we said, okay, you guys, you bring your own staff, we bring also ours. We bring our mediation committees, which is the Abunzi system, kind of keeping the traditional justice in a way in the hands of local and small cases. So we kind of like, struggling with that. But the good thing, which actually shows that there is a progress, was at least we got rid of these Conseil d'Etat, Cour des Comptes, all these courts which were more special and specialized, which were part of this civil law system in the beginning that was initiated, that was kind of like until 1994. And then we have a law, the organic law that is dealing on a functioning jurisdiction of the Supreme Court, which just says that judgment, the decision of the Supreme Court shall be binding on all other courts of the country. But it's good to say, it's very beautiful and well said, but you're dealing with lawyers, judges who have never heard of what this means. And also you don't know where to find these precedents. Where do you go to find it? Where, most of these decisions by the Supreme Court, they are, there's a document. How do you teach a lawyer or a judge to find a precedent? Is it the whole case, or do you go and look in the text? Which part of the judgment is actually a precedent? How do you define that? And that is whatever, will be done. Judge will still struggling to know, when I read a case, where do I find a precedent? How do I define what is a precedent? What is it? Is it like Supreme Court is going to define a list of the precedents, or am I going to go and check that? And that is a problem. And also there are judges who really enjoy the penal code, because it's nice. You open the article, you say this, and then the way I think about it is how I interpret it. And as a judge, because the civil law system in criminal procedure and criminal code is easier. You open the article, you read it, and I got it today, tomorrow I can change it, and that is actually what we're trying to change. But for the judge, he enjoys it, because depending on how he wakes up and finds this article, what he says today may not mean the same thing tomorrow. And we try to get them to see that you cannot do that, because there is a precedent. So connecting the precedent is very, very difficult. So, and from 1999 to recently, I've been working with an USID project trying to kind of look at justice reform in Rwanda. But you can create institutions, you can create codes by changing the minds of people in the way we think, the way we do things, because it becomes a routine. For that judge, it's very, very difficult. And I'll show you again a small picture about that. And also the issue of investigation. Then we look at the role of judicial police and where they still kind of control the investigation. And that's 5 minutes, okay. So and when you look at all these aspects, investigation, examination, where you see the prosecution still very much involved, but also looking at, for instance, an experience in Rwanda where the fight to get the prosecutor moving from the bench to getting down on the side of the party. It was a big fight, because the prosecutors used to be like the government. We are the government, we're just like the judges. So to move this person from, the top here to get him sit down in that corner is very difficult, because it feels like he was demoted. I was, a VIP, now I'm going down there. So the next step is actually moving him to sit next to these guys here, where the lawyers are actually sitting here next to the party, because now he moved from up there, he went a little bit down, but it would be very difficult to move him on this bench so that he can be like the same level as a lawyer, which is another step, but it would take it would take time. So another aspect when you look at the role of the judge is still a little bit active, although it's kind of like working toward making the judge a little bit because the judge is still involved, like for instance, to search for evidence. It's not really there yet. And we're talking about again the influence of Belgium and Dutch, who will say, you want a court, we're gonna get this also done. We have to keep including that, and that is also another aspect. And the court also still order the prosecution in some cases, and the evidence is still used like on all grounds, which sometimes the judge may not be involved in defining the evidence. And the role of the victims, which is still a big issue because the victim is still involved in the criminal trial, which sometimes may be also a little bit problematic because the fate of the criminal case is still affecting the victim's reparation, which in some cases may be really problematic when you don't allow the prosecutor, or sorry, the victim to use a different way of proving the reparation. So we still kind of depend on the trial. If the criminal trial ends up being guilty, then the victim will benefit. But if you find innocent, then it'll be very difficult because the trial has been set on a bar which is much higher in terms of evidence. So other factors, we have the bail, which was introduced, but still in Rwanda, it's not like anybody can pay bail. It actually has to be a person of high moral standing. So it's not like anybody will pay. You just have to be brought by somebody who has high moral standing. Who defines that? That is another aspect, because you have to define that paying bail, but you have to prove that you have high moral standing. And then the jury was not really introduced, but it was more in the system of Gacaca and the Rwandan traditional justice, which was kind of not really jury, but kind of more connected to that. And then now there is what they call the mediators, who are kind of courts mediations at the same time, trying to connect both the approach of a jury, but also at the same time using more mediation, which is kind of a combination. And the right of defense is also, it's still a big issue because the kind of presumption of innocence is there, but there are some steps where it will be very difficult, especially if you look at the psychological element, having a prosecutor a little bit having a better position. So moving forward, what we have here is, as I said, Rwanda is joining East African Community. And it looks like there is no choice because East African Community made by Kenya, Tanzania, and Uganda, and those are English-speaking common law countries. So Rwanda can, go slow, but at the end, will end up getting to a common law system. But also, we have to say that we have Burundi and we have Democratic Republic of Congo, which is also countries looking at Rwanda to see what we do next. If Rwanda move this way, usually DRC and Burundi will follow. Okay, so I hope I didn't.
No, you were great. Thank you so much, Jean-Marie. And so we're going to close out the discussion part of the panel with Olga Ruda, who's going to talk about Ukraine, where the CPC is not fully implemented, but aspects of it. And so
Sure, thank you. So I'm going to talk about Ukraine, and it's Ukraine is obviously presents a very interesting case in terms of the criminal justice reform, specifically in this context. So when Ukraine became a member of the Council of Europe in 1995, it undertook a commitment to implement a comprehensive criminal justice reform. Up until a few years ago, it was the last post-Soviet country that still had a Soviet-era criminal procedure code that was adopted in 1960 and had a heavy prosecution bias, no provision for equality of arms, very significant room for abuses, especially at pretrial stages. and almost no presumption, like such principles as presumption of innocence or to speak of, and there were almost no acquittals in practice. The document has been amended several hundred times since Ukraine became independent in 1991, but the consensus was that that was beyond repair. Basically, it was so ideologically based in the Soviet ideology, it was impossible to fix it. And since 1995, there were at least 8 attempts to pass a new criminal procedure code, but none of them was seen as terribly comprehensive. And as a result of that, and also political tensions, none of them made it beyond the first reading, really. In 2008, Ukraine adopted the Criminal Justice Reform Concept Paper, which envisioned a 3-pronged systemic approach to conduct the criminal justice reform that would involve simultaneous reforms of criminal law, criminal procedure, and institutional reforms related to pretrial investigation and other law enforcement bodies. And a new criminal procedure code was drafted based on that concept paper, but because of the change in the government, it never actually made it to the first reading in the parliament. Then, when the new government headed by then President Yanukovych came to power, about a year after that, they introduced the new criminal procedure code that was pretty much based on the previous draft from the previous government, but was significant sort of like step backwards. The working group that developed that draft was selected politically, and it didn't include any participations from opposition, from recognized scholars in criminal justice, or really from the judiciary. There was only a handful of judges in the working group, and none of them came from the Supreme Court, for example. There was no true public discussion of the draft. The opposition was entirely excluded from the process. And essentially, what happened? The government-controlled majority rubber-stamped the draft into law. The process of adoption was essentially lightning speed, and it was rife with procedural irregularities. So just to give you like a sense of how fast it was adopted, the draft was formally introduced in the parliament in January of 2012, and the final third reading adoption took place in April of that year, with the code being adopted at 4 o'clock in the morning or shortly thereafter. And there was only about 50 MPs present in the room during the voting, but the final tally showed that 270 of them voted in favor of the new document. And as a comparison, the previous draft code sat in the parliament for about 4 years without ever coming up even for a single vote. And then the other speedy thing about that was that the new code took effect only 6 months after being published. So it was in November of 2012, even though the international and domestic experts and legal community urged to have a 2-year waiting period to allow for training, because there was need for extensive training on the new document that would be applied by about 300,000 prosecutors, 18,000 investigators, 30,000 advocates, and 8,000 judges. So all of them only got about 6 months to really prepare on how to use the new document. So in the end product, there has been a mixed reception. There has been a lot of praise. The Council of Europe has said that this should be used as a model for other countries in the region that are trying to reform their systems. The domestic reception has been a little bit more mixed, with more of a consensus emerging that there is, sort of like similar situation to Rwanda. It's an adversarial system in spirit, but with holdover elements of inquisitorial system still. So what are some of the things that are inside this new document? First of all, there is a clear distinction between strengthening of the role of the defense against the prosecutors. There are provisions for equality of arms that apply not just for the trial stage, but also for pretrial investigation. And even though there is no separate provision on the rights of the advocates, these rights are now derivative from the rights of the suspects or the defendants. They are significantly broader than they were under the previous system, although the advocates are still critical that this is not enough compared to the prosecutors. The other development is that now only licensed and registered advocates are able to provide legal assistance in criminal cases. Until recently, it was any lawyer and also family members who are not lawyers could provide assistance. So this is again like a mixed blessing. First, it can allow to provide better quality legal assistance, easier to sort of regulate. But on the other hand, the majority of the people cannot afford to hire an advocate, and as a result, we have a situation now when Ukraine has about 30,000 licensed advocates, maybe about 4,000 of them are not practicing. And there's only about 2,500 lawyers who are registered to provide free legal aid, and these 2,500 lawyers provide criminal representation in about 80% of all criminal cases, because people simply can't afford to hire a paid attorney. So defense now has equal rights with the prosecutors to gather evidence independently during pretrial investigation stage, and to present its own evidence in court. And this includes rights to interrogate witnesses, to commission expert evaluations, and to demand discovery and production of evidence, and also to demand from the prosecution and investigation to conduct investigative action. However, that is subject still to the prosecution's and investigators' approval. And even though a denial can be appealed to court, the review will not happen immediately. It will only happen after there is an indictment and the case makes it to the preliminary stage of the trial, so the preliminary trial hearing. Defense also has access to a complete case file and the right to make copies throughout the entire preliminary investigation. Until recently, it was only after the close of the investigation and the case was being, indictment was being forwarded to the court. And although prosecutors still can, they can still reject the requests if they think that showing the case file to the defense can hurt the investigation. So there is still that loophole. And prosecutors, importantly, also no longer have the right to directly conduct investigations. However, what they do is they exercise procedural management of the investigation. And essentially, this role has become a micromanagement role where they can give any kind of instruction to the investigator. They can remove an investigator, reassign an investigator, and at the same time, they don't have any, essentially, they're shielded from any liability because they don't sign off on any kind of documents or any kind of decisions throughout the process. And there is also continuity with the prosecutors in the sense that there is only one prosecutor assigned to the case from the start of the investigation until the end of the trial. Previously, it was very common for a new prosecutor to be assigned minutes before the start of the trial, and then that would result in delays because that person would need time to prepare for the case. There have been significant reforms at the pretrial investigation stage. So now the criminal investigation launches automatically as soon as there is a complaint from a witness or from a victim or from anyone else about a crime. And anyone can file a complaint, even if the investigator feels that there is no merits to that complaint. They still have to launch an investigation, although they don't necessarily have to sort of declare anybody a suspect at that stage. And that actually creates a practical problem for the defense because what happens now frequently in practice is that the investigators and prosecutors wait until the very last minute to declare somebody a suspect, basically as soon as they're already ready to send the case to court with an indictment. And because that means that the person can be interrogated as a witness by the prosecutor. Those people don't they don't have right to be represented by an advocate, and also don't have the other procedural rights such as do their own engage in their own investigations, access to the case files. So they basically they're being processed as a suspect, but formally they're still in the witness status, and they don't get all of the rights. So that's been a concern. One of the really revolutionary changes, and that's been the consensus from everybody involved, is with the use of different precautionary and pretrial restraint measures. So there, until recently, there was overuse of detention, pretrial detention in Ukraine. Now, any precautionary measure first must be based on a reasonable suspicion that the crime has been committed. Before that, the judge actually was prohibited from reviewing any evidence or evaluating any evidence of a defendant's or a suspect's guilt in imposing pretrial detention. So now they actually have to have the reasonable suspicion. the pretrial detention opportunities are very limited. So for most of the economic crimes, it's automatically now bail, and also for other crimes, for a first-time offender, to be able, for the prosecutor to even consider imposing pretrial detention, the crime has to be punishable by at least 5 years of imprisonment. There are new alternatives to detention, such as house arrest, personal commitment, and so like guarantee by an influential person in the society, and also expanded provisions on the bail. And bail also now must be offered in any case of pretrial detention. So there has to be an alternative mentioned. The person can go on bail if they agree to pay this amount, or otherwise they will go into pretrial detention. And this applies to everything except homicides and violent crimes. So the role of the court is also expanded now. There is a new procedural figure, the investigative judge, who basically oversees the entire pretrial investigation period on behalf of the state and makes all the procedural decisions. That includes any pretrial restraint measures, search and seizure warrants, any other investigative actions. Before that, it was either investigator would do it on their own, or just get a warrant from the prosecutor. So that's a new development. But the appointment of these judges is a little flawed. So basically, the general meeting of judges on each court assigns one or several judges from the court to serve in the investigative capacity for a 3-year period, and that means that it opens opportunities for corruption for prosecutors to basically know, like, okay, I have to work with I have to work closely with this judge for the next 3 years and be nice to him or her, and that's certainly been seen as a flawed process. The court no longer can gather evidence on its own, and it also significantly can no longer return the case for additional investigation. That was a common delay tactic in the past, and also a way to avoid acquittals. Where a judge would, at the end of the trial, would see that there is not enough evidence to convict a person, so there are doubts, but because he or she didn't want to issue an acquittal, they would return the case back to the investigator and say, okay, you have to investigate more and come up with additional evidence. And that could go on and on and on for years, with some cases sitting in these stages for 5-6 years periods. And now this is no longer possible explicitly. So there are some evidence reforms. Okay, let me just run through this quickly. There are new rules on the standards of proof. That's an introduction. The admissibility rules for evidence. Basically, all of the evidence must be presented in court now, and evidence that was obtained illegally is no longer admissible. There are provisions on the plea bargaining and reconciliation agreements between witnesses and victims and defendants. There is something that's been called the jury trial, but it's really more of a quasi-jury trial, because there are 3 jurors and 2 professional judges who decide the entire case as a panel jointly. So the questions of fact and the questions of law. And the significant thing is also that the new code is now in the transitional period. So until there are still pending cases that were filed with the trial courts before November of 2012, the old criminal procedure code will continue to apply to the old cases, and that includes trials and appeals for those cases. And just by way of example, in 2013, it was about 47,000 cases that were still tried under the old rules, and about 27,000 appeals, and the numbers are going down, but still both rules are applicable. I think do I have 2 minutes?
Yes,
or okay, thanks. Just to to talk about some of the accomplishments. The new code has succeeded in reducing the number of pretrial detentions significantly, from about 4,500 average detentions per month in 2011 to about 1,500 average detentions per month this year. So far, the reduction in prison populations in pretrial facilities went down from about 32,000 people in detention to about 18,000 as of the end of last year. There is a lot of room for use of alternatives to detention. So detention is now only used in about a third of the cases, and about 50% of the cases, people are basically released on their personal commitment that they will show up when summoned. The use of plea bargains and reconciliation agreements has taken off, and about 15 to 20% of cases have been settled through plea bargains or reconciliation with the victims. The jury trials have also been used in a few cases, but the only cases that they can be used for are those punishable by life imprisonment. So there's been a small number of cases, and all of them still ended in convictions. The one thing that the government really was hoping for and that didn't happen was the change in the acquittal rates. So Ukraine had notoriously low acquittal rates, only about 0.2% in 2012, and these rates went up to 0.6% in 2013 and 0.5% this year so far. So it's still, and the government was hoping that it's going to go up to 35% within 2 years. So that's still, there's still way to go. And a lot of that has to do with the mentality challenges, because the judges are still, afraid. They're working with the old system. The reform has been piecemeal and incomplete. The prosecutorial reform hasn't taken place. The judicial reform, the law enforcement reform. So until all of that happens, there are still going to be some challenges with the implementation of the new system. I can probably talk more about that if there are questions.
Thank you. And before we open it up to questions, I would like to ask the panelists one question. I think all three of you talked about mentality changes, and it somewhat ties into kind of my opening statement about the why. And so do you have any recommendations for us on how do we best address the mentality changes, or specifically with the prosecutors, how to get them to move off the bench and be on par with defense counsel and see that as a good thing and not a demotion? So I throw that out to all three of you.
I think the first step that happened, just move the chair, put it where it should be. So just put one. That's what happened in Rwanda. Just you move the chair and it knows that it has to be there. And by the fact of being there, realize that her role is really moving toward being a party, not as the government. But also, I have to say that lawyers are mainly the most conservative people in the society, where it's kind of they have the way they've been doing things, and it's not easy to get a judge be a bit more neutral, passive when it's used to kind of being active person. So and that is where you find that if you involve all the parties involved, like the bar association, the prosecution, and the judges, instead of kind of training the judges there and the prosecutors there and then the lawyers there, if you put them together and you train them together to understand the trial as in a big picture, then they see it. But if you kind of put one on one side and then another one side, another side, it's a program. Unfortunately, most training programs or projects, they either look at prosecution or judges or lawyers, and that's what I find a little bit problematic.
Okay, great. Judge, do you have any insights?
Yeah, I don't think it's very important to move the prosecutor off the bench. I think that would be a mistake in many cases. I hate to disagree with you, and here's why. Historically, prosecutors are part of the magistracy. They're like judges. They go to school the same way, and they have certain benefits that are very much like judges. And so to simply say you're now down here with the crowd is a rather rash move, because I don't think that's really where the problem lies. I think the problem lies in getting strong political support for the kind of modifications that you're looking to have. You need, in Brazil, you get the president, Lula da Silva, and he says, we're going to do it. They did it. You have a legislator who's the head of the Judiciary Committee, who's a professor of constitutional law at the University of Sao Paulo, and after 20 years of fooling around, you get major revisions. You get leading academics, you get leading members of the bar, and you get people who say, this is how we have to modify our criminal justice system. It may involve ultimately moving magistrates, prosecutors off the bench, but I don't know who's the one who makes that decision. I can see that in a lot of instances it might cause resentments. So, I mean, I think if you want my advice, what I would say is identify the key leaders in the legislature and even somebody who's likely to be president in the next 10 years, bring them here, wine them and dine them, show them our system, show them how it works, and then let them go back and try and lead the charge. It takes a long time for that to happen. And as I say, I think this first move, largely symbolic, could create more resentment than it should. There are other ways to go at these issues. There are more profound issues in my view. But the idea that the prosecutor is part of the magistracy, as I would call it, I guess, to distinguish it from the judiciary, very common in civil law countries. It's a hard thing to simply, I think, unilaterally change. And you really haven't weighed the consequences much of the time. I'm not sure what the benefit is other than symbolic. And then through all these leading people, really work on your community outreach with articles, with seminars, with newspaper articles and so on and so forth. You get your people in a whole conspiracy, if you will, of change. And I'm sure you've done all these things before, but I've seen it over maybe a 45-year period finally bring fruit in Brazil. And there really isn't any problem, in my view, in Brazil still seeing the prosecutor alongside the judge. No special benefits because of that, just more of the historical combination.
Well, so in Ukraine, the prosecutors actually don't sit on the bench. That was sort of like that hasn't been the case under the Soviet system, so that's not an issue there. But obviously, the prosecutors have significantly greater mentality challenges there. One thing, whenever there is an acquittal in a criminal case, the court acquits somebody, a prosecutor who was prosecuting that case is subject to discipline. That's the disciplinary provision. And so, of course, they don't see it as a true adversarial system because they see basically any their loss means that they've messed up really badly, and they may be, depending on how politicized the case is, they might be removed from office. So that's one thing, you have to get rid of sort of like that thing. The role of the prosecutors over the judiciary, the judges, one of the reasons why they're afraid to really issue decisions against the prosecutors is because, I mean, they're afraid repercussions and persecution because the prosecutors may then try to sort of like initiate either criminal cases or disciplinary proceedings against judges. So the judges don't want to risk that, and they also have sort of like good, well-established relationships with prosecutors. And in Ukraine there have been a lot of discussions lately. I mean, like obviously since the new government came to power, there's like a lot of people see it as an opportunity to really cleanse the systems, the government systems from the corrupt and officials who in different branches. So, for example, there is a law on lustration that has been passed recently, and a lot of the law enforcement officers, the police officers, will be subject to that law. There also has been a separate law on lustration in the judiciary, but that applies mainly to the leadership of the judicial system. The pending draft law on the prosecution that's now pending for the second reading in the parliament actually includes a section on integrity checks and illustration for prosecutors. That will happen within the first year of the adoption of the new law. So hopefully that will help, bringing some fresh blood, some new faces to the system. And help start moving forward that way. And another thing for mentality for judges, there is presumption of innocence in the Constitution. There is presumption of innocence now in the new Criminal Procedure Code. But under the old system, the defendants, even those who are not sort of like in pretrial detention, they were placed in cages in the courtroom. So there is a cage inside a courtroom. A defendant sits in the cage during the entire trial. Now those cages, so basically the bars have been removed, but they have been replaced, and that's actually provided by the new code. They have been replaced by the glass enclosures. So they're still sitting separately from their lawyers, from everybody else. And, it's hard for a judge to see that person as not being guilty of a crime if they're already sort of like being separated like that. So that has to go, I think. That's probably more important than also, like, frankly, moving the prosecutors off the bench and then...
So I'll open it up to all of you for any questions that you have back there.
Hi. Thanks to the organizers and to the panelists for speaking. Thanks. My question is,
along the same vein of mentality and changing hearts and minds, what about in the cases of Ukraine and Brazil and Rwanda? Have there been counter reforms, so to speak? We've seen in the case of Mexico, members of civil society or individuals or groups actually saying, this reform is not in the best interest. Let's stay with the status quo. So I'm curious to know about experiences in these other countries we've mentioned. Thank you.
I think he's directing.
All right. In Rwanda, I think the resistance is more coming from the civil law lawyers who are trained in that civil law, because change is very difficult. I mean, you don't want to send somebody who's been in school for 10 years to say, okay, what you did is wrong, so you have to go back and learn again the best way of doing things, because going to school and everything was like, I got it, so now I'm not going to learn it again. So that the resistance, it's not really from the citizens, because of all the good things we get from the acquisitorial system, the beneficials are the citizens, and they see it as a positive move, where the perception of looking at the prosecutor and knowing that prosecutor has to prove a case rather than being the prosecutor and judge ganging together against the lawyer and the defense is something people are learning. So the resistance is more coming from the lawyers who are particularly the prosecutors, who see their job being a little bit harder and difficult to do because they are being challenged. It's something they're not used to. But with time, it's more kind of for moving forward. And I don't see any resistance, particularly in the context of Rwanda.
Maybe I can weigh in on this as well. There's been some suggestion in Rwanda that the Supreme Court decisions will be binding on all cases thereafter. That's an interesting point of view, and it's not necessarily wrong in general concept. It may just be an overstatement of what the way to go about that issue. The concept, of course, of precedent is that it keeps you from deciding the same case over and over again. So it means fewer cases get in the system, or they go out faster. But there's a legitimate point of view for there not being precedent. When you go back to the Ancien regime in France, everybody was afraid of the judges. Judges don't make laws, what they said. So let's just have judges decide cases and let the legislature make the law. And that mentality still is out there in a lot of countries. Interesting again in Brazil. They finally, largely through the efforts of members of the Supreme Federal Tribunal and some key legislators, adopted a decision with regard to binding precedent, but only in the Supreme Court, and only if 8 of the 11 ministers vote that this decision will have binding effect. So there are gradations that you can go about with regard to some of these things, which are not all or nothing. I mean, they are nuanced, and you've obviously found resistance from the people of the earlier school who said judges shouldn't make law at all. Of course, we, at least in the America, we know the little secret that judges always make law when they fill in the gaps. But according to the civil thinking, judges don't, judges shouldn't. And so there are approaches that have to be, I suppose, in the manner of compromise.
So in Ukraine, I mean, there has certainly been resistance under the old government still from then opposition to the law, and like I said, they have been excluded from the process of drafting or the adoption of the law. So they legitimately felt that it didn't take into account everything that they wanted to. But the greater concern for them was basically they were kind of like playing the tune that anything that was pushed through by this criminal government at that time cannot be good or positive or legitimate. So a number of draft laws under the previous system have been registered with the parliament to either repeal the criminal procedure code or to postpone its implementation, but obviously they didn't pass through. The consensus amongst the expert community, even domestically in Ukraine, has been that the new criminal procedure code is very progressive. Yes, there are loopholes. Yes, there are certain inquisitorial elements, but they were hoping that once the new government comes into power, it will be relatively easy to fix any of those loopholes just by very targeted, well-pointed amendments, and the system can work. And I guess surprisingly also there has been a lot of resistance to the new law from the bar. So like similar situation to Rwanda. Their lawyers, they have a lot more powers, but they don't really know how to use them effectively, or they don't really understand a lot of the provisions. So that has been sort of like taken as an explanation. And in terms of counter reforms, they have been related in Ukraine. Like they have been relatively narrow and have been related to really the political situation and the current the war situation that we have with Russia. So a law was passed in August that basically took away the powers from the investigative judges and transferred them back to the prosecutors in the two regions in Ukraine that are currently the center of the anti-terrorist operation, but essentially the war with Russia. Because the judges in those regions, the explanation has been given that the judges in those regions don't want to work at all. They don't want to basically come out and function. So it's better to have at least the prosecutors, issue arrest warrants and search warrants and things like that. And that hasn't been, well received, but that's the reality. And another suggestion has been the president recently came out with a suggestion to introduce the possibility of trials in absentia for former government officials of the former government who were involved in corruption and in the crackdown against the protesters over the last winter, and a lot of those officials are now basically hiding from justice in Russia. So there's no way to get them extradited, and the new government still wants to bring them to justice by basically trying them in their absence.
Actually, I wanted to make another point. Why don't we entertain questions if you give me a minute at the end to make a different observation on a point? I don't want to usurp that time.
Each of the panelists, I'm Beth Brownson. I'd served as a justice advisor in Afghanistan and was a trial lawyer here for 20 years first. Each of the panelists talked about kind of a top-down way of making change. And I'd be interested to hear in what kind of grassroots movements there are. If you think of in our own culture, where rule of law and justice is included in our high school history curriculum. We have bar associations going out and doing a speakers bureau talking in high schools. We have a high school mock trial program that the bar associations use to inculcate that sense of justice. And from way, way back when, anybody in the room who's old enough, from Perry Mason on TV to Law and Order Today, reaches out to the masses to get people to understand what their rights are and what the system of justice is. So I'd be interested in hearing those parallels to bring rule of law into the countries.
In the context of Rwanda, that's the movement I was talking about, because there is really a strong move to empower citizens to try these very small cases. I mean, the Abunzi cases, for instance, where the issues related to land, issues related to very minor cases. And that's where the empowerment is happening. But it's very difficult in a system where justice has been kind of owned by the top, the elite, because justice from historical context has been kind of in Rwanda. They lead the lawyers, the judges, the prosecutors. It's kind of like up there. So the citizens have been a little bit more passive in that situation. It's only with the Gacaca approach where people were kind of involved in trial genocide, and also currently a new move to kind of create what they call Abunzi, the mediation trial kind of approach, that the movement is kind of like going, but it's kind of parallel. It's not like there is a change that is going to affect the top. It's more like we give you the power and you're going to know what you have to know, but we continue the top-down approach.
So, Ugo, do you want to talk about Ukraine, and then Judge, you can give your
Sure, yeah. I mean, for Ukraine, I mean, there hasn't been a lot of sort of grassroots room for grassroots movement during the old government. Although the original criminal procedure code that was developed by in 2009 and that the draft that was sort of like used as the basis for the current draft that was changed for the current law that was changed by the previous government, that included a significant participation from the civil society. It was developed by a working group under the president, and a lot of civil society representatives were a part of that group. And more recently, sort of like very shortly after the new government came to power earlier this year, a group of different basically people who work for a number of human rights and reform-oriented NGOs in Ukraine came together to form sort of like a joint initiative called the Reanimation Package of Reforms. And they have proposed a number sort of like of initiatives. One of their working groups is actually a group on judicial and prosecutorial reform, and they're working also very closely with the members of parliament. So, for example, the new law that was just passed on lustration for the government, that was drafted as part of this initiative, and then several MPs who are working closely with them actually lobbied for the adoption of that law in the parliament. And the new draft law on the prosecution system has also been amended significantly by this group. And so, for example, things like integrity reviews and the transparent appointment systems for the prosecutors, these are the initiatives they came out directly from this grassroots initiative, and they're not being considered by the parliament.
I want to comment on an observation that I had about the last session, particularly the film that was shown. The lawyers who were shown who were interested in training lawyers, I suppose, the criminal defense bar through the Bar Association. It's an interesting point. The impression I had, though, are these may be people who are more being subject to political type repression than the average guys who are at the bottom of the scale who are committing ordinary crimes. Those are the people who in most countries that I'm familiar with, they need the support. They can't contract private lawyers. So we're talking public defenders. That's really where the effort lies to deal, in my view, with ordinary crime. Prime the public defenders. You've got it now in Brazil. It's a constitutional requirement. You've got it in Argentina. You've got it in Chile. You've got it in Colombia. That's where the major effort is. Candidly, in my experience, the very well-to-do people really probably are not punished anyway. At least that's the case in Brazil. Historically, it's been, they don't, until recently there was a big scandal where people were punished who were politically connected. And the other people who can afford lawyers, well, they can afford lawyers. And it's good to teach those lawyers techniques too. But I think if you're talking the greatest good for the greatest number, you're talking public defenders, you're talking about getting a commitment to have public defenders, and you're teaching those people the techniques. That's a very important distinction to make in terms of dealing with these situations. Who is the defendant that you're addressing? And I think you're mostly in the average crime, which is what most countries face all the time. You're talking about these guys. You're not talking about the political people, although it's an important group to talk about. So I leave you with that thought. That's my reaction as I've dealt with this now going on 50 years.
Well, I want to thank all of the panelists for giving their insights on the various countries and regions. We've learned a lot. It's very interesting, and we'll continue to monitor and see how the reform and transition takes. So if you would join me in thanking them.